Hi, everyone. Welcome to the lecture for week 2 of Juvenile Justice. And this week we're talking about the legal framework and rights of juveniles within the system. So, something that we have to talk about right away is the difference between a status offense and a delinquent act. And the reason why this is important is because juveniles are one of the only groups that have this dual classification. So, a status offense or a status act is the act itself is criminal because of one's status. And I know it probably seems a little confusing. So, very specifically, status acts are illegal because the person who committed that behavior is that person. I know I'm trying to be vague with this because one thing that is known is status offenses are typically seen as unconstitutional and illegal. So in most cases, you can't make a crime illegal just because the person committing it is that person. So very specifically, what's often known is local ordinances that say, you can't, no solicitation is, an attempt to make sure that homeless people can't gather around a certain area. They're not status offenses because they phrase them that way. But if they specifically targeted homeless people, that would be a status offense and would therefore could be challenged for unconstitutional. So a status offense, literally, it is illegal because of the person's status in society. The only fully legal status offenses that we have here in the United States is for juveniles. So very specifically, juveniles can be charged with a status offense. And these status offenses for juveniles tend to be things like underage drinking, underage smoking, not going to school when they're supposed to, which is called truancy, breaking curfew, running away from home. All of these things are technically considered illegal, but they're not illegal. They're not laws. They're status offenses. They're illegal actions because they're performed by a minor. So that's what a status offense is. The act is criminal because of one's status. Because a kid doesn't go to school, that is considered a status offense. That is illegal. They have to go to school. Delinquent acts, and this is the important piece that I hope you get. Delinquent acts are actions that would be considered crimes if performed by an adult. In the juvenile system, we call them delinquent acts, but they are breaking the law. These are things like theft, arson, assault, battery. All those things are considered delinquent acts if they are committed by a juvenile. We will talk later when we talk about murder because that is a separate thing that we have to talk about. But it's very important to note, status and delinquent acts, the difference is what the behavior is considered. Anything that would be a crime is a delinquent act. Anything that's only illegal because it's a child is a status offense. And so the reason this is an important distinction is because children are still developing. They aren't full adults, so they cannot be held to the same standard as adults. They are not as responsible. So I do want to say real quick that as far as status offenses are concerned, the rationale often behind why these are considered, quote, illegal is because stopping individuals from committing this is stopping them from further harm or danger. So the idea of a kid is skipping school, why are they skipping school? Often it's to commit delinquent behavior, so stopping them from skipping school is actually stopping further harm, that kind of thing. It's just a side piece I want to make sure I emphasized here. So I also want to point out, because of the difference, punishment looks different depending on the type of act. So it should be noted, and you should identify this for yourself in some way, shape, or form. Because delinquent acts are actual criminal behaviors, they might have very different punishments than a status offense. If a kid is caught for truancy, for not going to school, do they need to spend time in jail? No. That's unnecessary. But if a juvenile set fire to 3 buildings, yeah, they might need to spend some time in some kind of detention. So, yeah, the punishment will change depending on the type of quote-unquote criminal behavior that they're doing. So, I jumped a little bit. I was going to say real quick one more thing about this. For status offenses, the punishment tends to be towards intervention and alternatives to incarceration, like therapy, counseling, community-based programs, that type of thing. Excuse me. Part of that is because there is a labeling stigma behind status offenses, and we're going to talk about labeling theory next week. But it's important to note that because there is a stigma attached to criminal behavior and being referred to as a quote-unquote delinquent, there is a push towards alternative punishment for status offenses versus delinquent acts. It is also important to note that there's a disproportionate impact to marginalized communities in our current system, and so that does lead itself to certain conversations which we will have throughout this class. And we talked about it a little bit at the end last week, but school plays a big part of this, partly because, one of the status offenses that a juvenile can have is not going to school. So school does play a big part, and we're going to get into that in a little bit. So let's talk about constitutional rights, because I feel like that's one of those things that people want to talk about the most with juveniles. And in general, people just want to know, especially now with things changing in our country and the way things happen. So I think it's worth talking about. So some constitutional rights, it's important to note that juveniles are citizens of the United States. So they are given the same rights and constitutional rights that any other citizen is given, with a big asterisk. It should be noted that since they are still, under the age of 18, they are not legally an adult. They don't have the same full access to constitutional rights. For example, a juvenile does not have the right to bear arms. Just in general, there's pretty serious laws about how young somebody can own a handgun and a firearm. So, they don't really have the right to bear arms. They don't have voting rights because they're not yet of legal age to vote. So not every constitutional right is given to juveniles. There's also a whole conversation about the right to privacy, which we'll get to later. But the idea here is that for the most part, they get the big rights. They get the ones that do matter. So technically, juveniles still have the right, the First Amendment right, the freedom of speech and expression. How a parent handles their child in their own home is not a First Amendment violation because the First Amendment protects you from the government silencing you, not a school, not a parent. So it's a whole different conversation. But it is important to note that, they have the right to express themselves. But what's important for us for this class to talk about is they have the right to due process. And due process, something that I can't believe I have to be having this conversation in 2025, but due process is the legal right that everyone who exists in the United States, whether they're here legally or not, they have the right to due process. That means that they have the right, because they are on American soil, to be processed through the legal system with all the same opportunities. And so this means that even juveniles, they have the right to be told of their charges. You can't just arrest a juvenile and put them in detention, you have to go through the proper process. You have to give them notice of their charges. You have to give them the right to be heard, aka their chance to plead their case, and they have the right to have an impartial decision maker. They have that right. So, and there's way more to due process, and we will talk about it in the coming weeks. But it's just important to note that, yeah, juveniles still have the right to due process, even though they're kids. And of course, they also have protection from cruel and unusual punishments. What we like to talk about in particular here is proportional. And this is kind of going back to the little example I gave earlier, which was just kind of a throwaway example of you wouldn't put a kid who's truant from school in detention. You wouldn't put them in, a jail for 40 days. No, that's not really proportional to their crime. So the protection from cruel and unusual punishment means that, you can't get you can't get like free slave labor from a juvenile for the next 2 years of their life. No, that doesn't quite work, especially for a lot of the crimes that they may have committed. The whole idea is that the punishment is appropriate to the crime that has been committed. Another part of this that is not written here, but what this looks like in our juvenile justice system is we try to put forward the concept of dignity, that the individual, the juvenile, has dignity. They are a growing child. They are not some 55-year-old person who is not changing their ways. They are a kid who's still learning. So we treat them with dignity. I will gladly say right now, I would argue that we should treat everyone with dignity no matter how old they are and no matter what their circumstances are. But how our system works, that's kind of what I'm talking about here. So the right to counsel is a very interesting constitutional right. We are going to talk about it in coming weeks because the right to counsel, which of course means the right to have a lawyer, was not always there and not always clear. And this has a weird history to it, which is why I said we will talk about it later. But the right to counsel, sometimes, and I'd argue most of the time, kids need to, and their families, need the legal system explained to them. And that also means they have the right to be represented and defended. So, yeah, the right to counsel is actually super important because a juvenile is not excluded from having a lawyer help them. They are allowed to have a lawyer help represent them. And like I said, we will talk about that history later because it is a little more complicated than what it seems. And perhaps one of my favorite ones that students oftentimes don't think about, but I like to remind them, is that juveniles are due their Miranda rights upon arrest. The Miranda rights are something that most people are familiar with because of television and cop dramas have, really burned it into people's brains. You have the right to remain silent. Anything you say can and will be held against you in a court of law. If you can't, you have a right to an attorney. If you cannot afford an attorney, a state-sponsored attorney will be assigned to you, etc., etc. That kind of thing. It's not necessarily verbatim, but that's the kind of stuff that we're talking about is the Miranda rights. And yeah, juveniles are supposed to be given their Miranda rights. They are legally required to know that, what they say can be used against them. It's the whole trying to prevent self-incrimination. So yeah, this is actually a really important right. It is constitutional, but it's not a constitutional right. It's a little weird gray area. But it's important to note, juveniles do still get Miranda rights. Why would I emphasize that? Mr. Wheaton, why'd you emphasize that? Because it may be a question on a quiz or an exam. All right. So there are some general issues with the way that our system, our juvenile justice system works and operates. And I picked three of them. These are some of the three that are some of the three. These are three that are talked about in the chapter, and I also think that these are three fairly serious issues and fairly straightforward issues that I think we should discuss, and I think could help with an exam question later on in the future. So, one of the issues in our justice system for juvenile justice currently is the balance between public safety and youth rights. And this is something that's been going along for a while, and it's a unique problem that juvenile probation officers deal with. And that really is, there is a push between what the public feels as their personal public safety and what is the actual rights of the youth who committed a crime. So, for example, if a juvenile delinquent has stolen from several neighbors' properties, and, it's a fair judgment to say, okay, they need to be punished for stealing, and we need to make sure that the public feels safety, that they're not going to be robbed again. But at the same time, is just putting the juvenile away, does that really solve the problem? Or do they need some kind of alternative approach? Do they need certain group therapy? Do they need certain procedures? Do they need individuals to talk to? Do they need guidance? And so it becomes this weird balancing act. And so the probation officer, if a juvenile goes to juvenile detention and then is released back out early, they once again have to deal with public safety concerns. They want to make sure that the juvenile is, themselves safe and recovering, but they also want to make sure that the public isn't concerned about the juvenile, and oftentimes public perception can change a lot of things. So it's a weird balancing act. So this is a big issue, is the balance between public safety and individual rights of the youth. I'm going to jump to the last one, and then we're going to come back to the middle one. So I said we would talk about murder, and we are going to talk about it again later. This is my first little dip into it. So there is an issue of transferring juveniles into adult court. There is a process called a policy of bindover, or a policy of... It's a particular policy, and now I'm drawing a blank on the other name for it. But the idea here is that if a crime is serious enough and they believe that the juvenile is mature enough and cognizant enough to understand the severity of the crime, that they can be transferred to adult court. Oftentimes, this is used for murder. It's most other crimes, they typically don't see this transfer to adult court frequently. It tends to just be murder cases. But other crimes can go through this process. But this is an issue because, and we're going to find out more about this in this class. Well, we as in you, not me. I know about this already. But what you'll find out is that the juvenile system tries to minimize punishment. It tries to minimize the time in prison and incarcerated. They're trying to reduce the punish side of punishment. Whereas the adult court system is still very punish heavy. And so by transferring a juvenile into an adult court system means that there is a more serious side, a more severe side. And so there are issues that come up with that, and people kind of go back and forth on whether it should be allowed or not. Which brings us to my third one, which is in the middle, and it's why I said about the maturity level. The age of criminal responsibility. This is a concept that's very debatable. And the reason I say it's debatable is because there are experts who go on the lighter end and some that go on the heavier end. Some go way deep into 8 and 9-year-old is criminally responsible for some crimes. Others say they're not criminally responsible till 16. The whole concept of the age of criminal responsibility is at what age can a juvenile, can a child be considered responsible for the actions that they committed? And so one that we often hear the debate about is school shooters. And recently, i.e. the last couple years, we've actually seen a discussion about parental liability for school shooters and criminal responsibility. The Ethan Crumbley case, Crumbley. If you're interested, just look up the Crumbley case. It's the first case of a school shooter here in the United States where the parents were held criminally responsible and are liable for his behavior. It's the first. So this is an emerging field, but the age of criminal responsibility is a debate that's been going on longer, and it's why it's important to talk about this. Is how young is too young, and how do you know when they're old enough? And I'm going to tell you right now, as your teacher, I don't know the answer. And if you ask people in the field, some people are going to have a direct answer and others don't. The reality is this is one of those that does not have a direct answer. The age of criminal responsibility is not a hard number. It's not a, oh, you hit 13, you're criminally responsible now. It's kind of a weird sliding scale, and it's difficult to talk about. And definitely if you look into particular juvenile cases, you can look into several different cases of people under the age of 13, plenty of different kids who have technically committed murder. And depending on their age, sometimes determines their sentence and all these other things, because the age of criminal responsibility is an issue. It is a big debate. All right. We got to shift gears because, let's be honest, that was a little depressing. So I want to actually talk about the process. So what exactly does the juvenile criminal process look like? And honestly, it's the same as the adult process. And what I mean by that is it really is a mirror. I will tell you right now, pay close attention to when we talk about comparisons between the adult criminal justice system and the juvenile justice system, because it will come up in a later exam. Hint, hint, nudge, nudge. So the process of the judicial process for a juvenile delinquent is pretty much the same as the adult process. However, we change some of the words, and it's a little bit more streamlined. And it's because ease of access and ease for child understanding. So it is a fairly quicker, more streamlined process. However, if somebody was to ask you how are the juvenile justice and the adult system similar, well, they have a very similar process. They have a very similar style. They have similar structures for officers and things like that. But how are they different? Well, they may look the same, but they're actually very different. And so here's your juvenile justice. So number one, at the beginning of the juvenile justice process, intake. Intake happens for both the adult and the juvenile system. But intake is always, getting the demographic identification and information of the quote-unquote perpetrator, suspect, etc. In the juvenile system, intake leads to determining how to proceed. Oftentimes in the adult system, before the person is arrested, there's already a decision of how they're going to proceed. There's at least some conversation of where the next step is. In the juvenile system, once they're taken in, that's when they start to determine where is that next process. And so here, this is where we get some terms. So there's the detention hearing, which is exactly what it sounds like. It is a hearing to determine whether or not the individual needs to go to a detention facility, as well as to officially, talk about the official sentencing the official reading of the crimes. And then we get to adjudication. An adjudication is the big fancy word for the trial. In the juvenile system, we call it the adjudication hearing. And that's exactly what it is. It's where both sides get to put forward their case. The disposition hearing is they've gone through the trial, and now we're hearing the sentencing. And then after sentencing is the post-disposition review and rehabilitation, aka you finish the court process and now you're going into corrections, whether that be community corrections, whether that be rehabilitation facilities, whether that be juvenile detention, whatever that might be, that is the next step. And I do want to note the importance right here, but not the last one, the penultimate one, the one before it, appeals. This is something that both processes have. Both the adult and the juvenile system has appeals. A juvenile can appeal their overall sentence. In the adult system, an adult can appeal their sentence. So they both have the right to appeal through the process. And then, just like everything else, the end goal is release, typically. Obviously, there's a few crimes that don't have release at the end, but for the most part, the idea is to release. And so that's the process. It's pretty straightforward. It's not super complicated. And if you notice, if you have taken Intro to Criminal Justice, or you will be taking it soon, you'll note that when we talk about the criminal justice process, it's a lot more in-depth than this. This is why I said the juvenile system is pretty straightforward. There's a whole lot less of extra things. But again, that's for a later time. So those who have had me before, or I should just say this. Those of you who have had me for any other criminal justice class know I typically don't give you cases to memorize, not even in criminal law. I give very few cases where I say you should know this because I think they're important enough significantly to changes that I want people to know it. So this is one of those. This is the first one I'm giving you, and I think this is like one of only two in this class, I think. And so 1967 in Galt. So Gerald Galt, at 15 years old, was charged with inappropriate phone calls to neighbors. Very specifically, it was some of it was explicit language and sexual in nature. So he was doing what teenagers do and do crank calling. However, one of his neighbors, who was a victim of this, called the police, and they arrived and they arrested him. And he spent 6 years in juvenile detention without ever having a formal hearing. So he never went before a judge, never got to plead his case, never had a lawyer talk to him. And so he spent 6 years in juvenile detention. Well, not all 6 years in juvenile detention. He'd spend a chunk of them in juvenile detention, then the other in jail until he was finished. For crank calling. For doing a prank crank call. And so, as a direct result of this, there was a big push to say that, okay, there needs to be a juvenile attorney for juveniles. Like, we cannot just... We have to have a formal system in place. Because if Gerald Galt had known that he technically was still given the right to a lawyer, he could have requested one, and that could have prevented the 6 years in juvenile detention. The whole process was unfair. And so the juvenile attorney had now very distinct roles in design, and it pushed for... this actually was a Supreme Court decision that said, yes, they are given the same rights as adults. So this is the importance of all this. But what we found is that because of Galt, we have the roles that a juvenile attorney has. And that is obviously, first and foremost, is the defender of rights. A lawyer's job, regardless of whether it's a juvenile attorney or not, is supposed to be the defender of rights. Their clients have rights, and so they need to be the defenders of that. If the police are not following proper procedure, they need to bring them up on that. They need to defend their clients' rights. The other things that they need to do is be an advisor. They need to tell their clients what exactly is going to happen, how best to proceed. They also might have to be an investigator. They might have to look into cases and be like, well, why is this happening? Because you can't always just trust the clear evidence that's put forward by the police. You need to do a little bit more. Sometimes you need to be the negotiator. You need to be able to work and get a fair plea deal for your client. And oftentimes, because especially with juveniles, they are not fully formed, they do not necessarily know enough, and their families might not be as informed about the process as it is, they need to be advocates. They need to be advocates for their clients and push forward and say this is what they need. So a juvenile attorney is a pretty intense job. It requires actually being there and digging deep for their client. So, okay, I want to make sure we're not jumping too far. So, with this Galt in 1967, if you remember from last class, we talked about the Juvenile Court Act of 1899. And I told you we'd talk about it again. And so, brief reminder, the Juvenile Court Act of 1899 is what established a juvenile court with separate rules and things like that. And so, of course, I told you we'd be coming back to it, and it's important to talk about it here, especially after talking about Galt, because Galt said we need attorneys. Juvenile Court Act said we need to have these be the key principal motivators behind this. And so, yeah, the 4 principles of motivated change from the Juvenile Court Act, and I'm going to tell you right now, these 4 will show up on a test. Their 4 principles are: number 1, that children should not be held as accountable as adult transgressors. Children should not be held as accountable as adult transgressors. Number 2, the objective of the juvenile justice system is to treat and rehabilitate rather than punish. Number 3, disposition should be predicated on analysis of the youth's special circumstances and needs. And 4, the system should avoid the trappings of the adult criminal process with all its confusing rules and procedures. 1899. This is the language they used. This is the rules. And in other words, if you have a hard time remembering the longer sentences, go for these. Number 1, kids are kids. They're not adults, they're kids. That's one of the most important aspects of this. Children are children. They're not little adults, they're children. Number 2, the goal is to help, not hurt. The goal of this system should not be to harm kids, but to help them. The third one, which is the one that people tend to get stuck up on, disposition should be predicated on analysis of the youth's special circumstances and needs. Each case is unique. Each case. Doesn't matter how similar a case looks, each case is unique. Each kid comes with a different background, with a different history, with a different set of circumstances. Every case is unique, and it has to be approached that way. And then, of course, the last but not least, keep it simple. Our adult justice system that's been around for quite a long time is full of complicated rules. There's a reason why the term legalese, the language of law documents, is its own separate, confusing thing. Keep it simple. When it comes to kids, keep it simple. And for the most part, that is the whole point. That is the point of the justice system. That is why the Juvenile Court Act of 1899 In Chicago, Illinois became a big component for the rest of the world and the rest of the United States. They're the ones saying these 4 things and saying, hey, you want to punish kids. I'm all for making sure the punishment fits the crime, but we got to make sure that we're remembering these things because kids are kids. And not all of them are in the right circumstances. And shouldn't we be helping them? Because that's kind of the key mission of us. Yeah. This is the point. And with understanding that help, not hurt, it's important to note that there are 2 components that is really encouraged in all levels of juvenile justice. And those 2 qualities are compassion and empathy. Compassion and empathy are 2 qualities that every role in the juvenile justice system, that is an encouraged set of qualities. Because again, kids are kids, each case is unique, and our main purpose is to help, not hurt. Showing compassion is one great way to do that. And having empathy, feeling for another child's well-being, helps make sure that proper guidance is given, not just punishment. That being said, that's the end of the slideshow. That's the end of the presentation. Thank you very much. And like I said, there will be a short video going over the assignment sheet. But otherwise, yeah, good luck. There is a quiz this week, quiz number 1. It'll be on content from both chapter 1 and chapter 2. It is open notes, open book, so feel free to use those. But yeah, good luck on the quiz, and I'll see you in the next video.